Hello, everyone. Welcome to Consumer Actions webinar on helping consumers understand smartphone and computer warranty rights. My name is Nelson Santiago, and I'm a community outreach manager with Consumer Action, and I am thrilled that you are joining us today. We have a fantastic program in store for you. Before we move into the program, I want to acknowledge and thank our project funder. We are able to present this webinar thanks to a consumer education grant from the Rose Foundation for Communities and the Environment. We are extremely grateful for the foundation's support over the years. Now, in case any of you are new to Consumer Action, let me tell you a little bit about us. We are a national nonprofit consumer education and advocacy organization founded way back in 1971. Over the years, our consumer education work has focused on a wide range of topics, including personal finance, insurance, housing, privacy, telecommunications and utilities, and many other topics for which learning about consumer rights is important, like the topic we're going to look at today. Now, before fully diving into the topic, I wanted let's get our feet wet with a couple of poll questions so we can get an idea of how much you might know, how much you might not know about today's topic. So you're going to see a question on the screen, and you'll have a few seconds to tell us if you think the statement is true or false. So let me put up the first question, and then you'll tell us if it's true or false. Question number one, a typical manufacturer's warranty covers mechanical defects, software problems, and accidental damage. A typical manufacturer's warranty covers mechanical defects, software problems, and accidental damage. Let us know if you think this is true or false by selecting either option. Let's take a couple more seconds. I'm going to close the poll and share results. Okay, so 25% say true, 75% say false, and the answer is false. A typical manufacturer's warranty covers mechanical, electrical, and software defects, but not accidental damage. And we'll be hearing all about how that plays out shortly when we hear from our speakers. And also, if I could just ask, if you're not speaking right now, please be on mute because we hear a little bit of background noise. Let's go to the next question. Question number two. The Federal Magnuson-Moss Warranty Act requires businesses selling products in 2 or more states to give a written warranty. The Federal Magnuson-Moss Warranty Act requires businesses selling products in 2 or more states to give a written warranty. Is that true or false? Take a couple more seconds. Okay, let's see what you guys think. Okay, 65% said true and 35% said false. 65%, you are wrong. It's actually false. The Magnuson-Moss Warranty Act does not require any business to provide a written warranty. However, businesses that choose to provide a written warranty must comply with the Act, which among other things requires clear disclosure of the warranty terms and before the sale, availability of the written warranty for products costing more than $15. Let's go to the last poll question. This one's about right to repair. The right to repair is a federal law that requires access to manufacturers' repair guides, parts, and tools in all 50 states. The right to repair is a federal law that requires access to manufacturers' repair guides, parts, and tools in all 50 states. What do you guys think? True or false? Let's close the poll and look at results. %39% said true, 61% said false. So here the majority is right. This is a false statement. While a few states, including California, have enacted laws that require that manufacturers of consumer electronics make repair guides, parts, and tools available to owners and to businesses that offer repairs, there is no federal right to repair law yet. And we will hear all about that very soon from our speakers. So great job, everyone, on the poll. Definitely, we're going to have a lot. We have a lot to learn. I'm glad our speakers will be busy a little bit in a few moments. But before I turn you over to our speakers, I want to tell you about two publications that we have prepared for this project. These are publications that you will be able to download and share with your clients and community. As you know from our earlier emails, the whole idea behind this Consumer Action Project is to help consumers understand their options and rights when it comes to protecting the often big investment that they make when they buy their phone, tablet, computer. These devices, of course, are a necessity for staying connected, and they take a significant bite out of our budgets, not only at the time that we purchase them, but also potentially when things go wrong, whether the device is in warranty or out of warranty, as we will be discussing. The two publications you see on screen are a multilingual 7-page guide that's on the left. It's the Computer, Tablet, and Smartphone Warranties, Understanding and Exercising Your Rights brochure. It's available for download on our website in English, Spanish, and Korean, as well as Vietnamese. There's also a single page, two-sided sheet with brief tips on what to know about computer, tablet, and smartphone warranties. The next slide has a few more details of what's in there. The brochures include, or they cover warranty basics, extended warranties, and device insurance, including what to consider when deciding whether you want to pay more for coverage. What kinds of factors do you have to take into consideration? We also cover warranty-related tips, warranty-related laws in the brochure, as well as some tips on making warranty claims. And next steps if you're dissatisfied with a warranty claim process, and we'll hear a lot of good tips today from one of our speakers. So this is a lot of good information intended to be available to you so that you can share it in the community. All of you will get links to these fact sheets in a follow-up email that comes out in about a week. And also in that follow-up email, you'll also get the recording link, as well as a link to the recording that will be on YouTube. And when you're there, I may as well remind you now, we would love for you to subscribe. If we have a chance, we'll drop in the subscribe link in the chat in a little bit. You'll also get a copy of the slide deck. And as well, if you are an AFC professional who's looking for the continuing education units, you will get the information you need in about a week. Now, without further ado, let me get to our speakers of the day. We will be hearing today, and we're very lucky to have Elliot Conn. He is the founder and principal of the law firm Conn Law PC. He is a graduate of the University of California, Berkeley School of Law, where he also serves as guest lecturer. Elliot has also lectured at UC Hastings and presented for organizations such as the National Association of Consumer Advocates, the East Bay Community Law Center, Housing and Economic Rights Advocates, and the International Organization of Lemon Law Administrators. Elliot lives in the San Francisco Bay Area with his wife and children. Today, we're going to learn from Elliot all about warranty laws and about our warranty rights and how to assert them. Thank you, Elliot, for being here. We will also hear today from Nathan Proctor. We are lucky to have him here today as well. Nathan is the Senior Director of U.S. PIRG's Right to Repair campaign, where he works to pass legislation that will prevent companies from blocking consumers' ability to fix their own electronics. Nathan earned his BA at Tufts University and lives in Arlington, Massachusetts with his wife and children. Nathan's going to talk to us or discuss the movement to expand repair rights across the country, including California's new right to repair law that takes effect this summer, as well as similar laws in other states. Thank you, Nathan, also for being here. If you have questions for Elliot or Nathan, please type them using the GoToWebinar question function. Type them into the webinar platform. My colleague, Monica Steinish, is standing by. She'll gather the questions and present them to our speakers after they are done with their presentations. So join me in virtually welcoming Elliot. Elliot, your mic should be on, and I can advance your slides as you need.
Thank you, Nelson, for the kind words. If you could advance 2 slides. So just brief disclaimer, while I am a attorney, I'm not your attorney. I'm also only licensed practice law in the state of California. While I'm certainly familiar and knowledgeable about the Federal Warranty Act and the relevant provisions of the commercial code, many of what I would say will be state by state. So check with your sort of local state law. So today, we're going to just sort of 1,000-foot overview of how the Lemon Law applies to smartphones and digital devices. So we're start talking about what the Lemon Law is, what kind of products it covers, what your rights are, and how to go about enforcing them. So the next slide, what is the Lemon Law? And the Lemon Law is a broad term that generally covers breach of warranty. It's encompassed by the various state and federal statutes and to some extent common law that creates recourse for breach of warranty. So at the top level, there's the Magnuson-Moss Warranty Act, as a federal act passed in the 1970s that provides relief for breach of warranty for transactions involving the consumer products. What's critical about the rights and remedies under Magnuson-Moss is that they look to the relevant state law. And with that, there's sort of 2 things that you have to look towards. First, nearly every state, I believe every state except for Louisiana, has adopted what's called Article 2 of the Uniform Commercial Code. There are some variations. The commercial code, it's uniform for a reason, and generally for breach of warranty, the remedies should be uniform nationwide. And here you're looking at what's called Article 2 of the Commercial Code, which is generally dealing with transactions for commercial sales. However, it would provide some remedies for consumer goods as well. And then each state does have their own state law enactment of the Lemon Law. I'm, as a California practitioner, and I believe the plurality of the attendees today are in California. I'm referencing California's Song-Beverly Consumer Warranty Act, starting at California Civil Code, Section 1790. California does have a very broad and robust Lemon Law that, as we'll see, generally applies to consumer goods. Other state Lemon laws are not so broad. What comes to mind immediately is, for example, Indiana has a Lemon Law. And in Indiana, as many of you may be aware, is where a lot of the RVs are made. And believe it or not, the Indiana's Lemon Law for some reason does not apply to RVs. So if your relevant state's Lemon Law does not apply to devices or smart goods or smartphones, you're going to have to rely on the combination of Magnuson-Moss and the Uniform Commercial Code, where the remedies might be somewhat less. So going to the next slide, what does the Lemon Law cover? And I quote a section from California's Song-Beverly Consumer Warranty Act just to give an example, where if you look at here, it's everything except for clothing and food. In California, with some exception for vehicles, the Lemon Law generally will only apply either to new products, so products sold as new, not used, or used products where a warranty is extended in connection with that sale. So sort of a refurbished good with a warranty would apply. The key in California really is whether the warranty was extended at the time of sale. Now, even if there is a used good where there's still warranty coverage, but it wasn't sold directly by or directly by the manufacturer or the warrantor. There still can be some relief. However, you may not be able to obtain relief under the Song-Beverly Act. And so similarly with other state laws, many other states will explicitly include used goods. Some will exclude used goods. And again, this is something that you have to look really state by state. However, if you look again, the Magnuson-Moss Act will cover all consumer goods, so no exclusions for food or other types of products, as will the commercial code will generally apply to movable goods. So the short answer is, what does the lemon law cover? What does the lemon law cover? In some form, the answer is everything. If you with the next slide, what are your rights under the lemon law? And as you'll expect from any lawyer to say and not be able to give a straight answer, it really depends. If you look again, because it's the statute I'm most familiar with, I'm quoting a section from the Song-Beverly section 1783.2 D1, which applies to generally consumer goods. If a manufacturer breaches the express warranty, then their obligation is either replace the goods or reimburse the buyer. In California, the Song-Beverly's provisions are unwaivable. You may look into the express warranty terms of the actual warranty itself, and it may say things like the buyer, the remedy is diminution of value, the manufacturer has a choice of giving you refurbished good or your money back. The manufacturer has to have an additional right as repair. However, if a state law's lemon law is unwaivable and it says something different, then the state law controls. Now, again, not every state law is different. The rights will also change depending on what type of warranty is breached, and it's something I should have mentioned earlier. There are various types of warranties. The written warranties are generally warranties created by affirmation of fact or a promise. Generally, with say an express warranty, that is a promise by the warrantor manufacturer that the product will perform for some period of time into the future. And with express warranty, you're looking at how the product performs during the express warranty period. Implied warranties, such as the implied warranty of merchantability, for the most part, you're looking at the quality of the product at the time of the sale. So was it defective when sold? Under some state laws, and certainly in California, the implied warranty merchantability period will extend some period in the future. There's also, if the product, say, breaks outside of the express warranty period, but it breaks for a defect that existed at the time of sale, you may still have recourse for breach of implied warranty. It would be what's called a latent defect that was not discovered until later on. California has good case law about the length of time that essentially in the case of latent defects, the period of time that you have to discover it is truly until you discover it, and it could happen years after the purchase of the vehicle. Under the commercial code, so Uniform Commercial Code section 2714, which provides sort of the baseline damages for breach of warranties. The damages are the difference in price, or the difference in value between what was the goods as warranted and the goods as sold. And if the thing just doesn't work at all, that's pretty easy. It's the difference between the price that you paid and scrap value, or difference between the price you paid and absolutely nothing. If the thing is glitchy or slower, that can, or even the specifications are not what they said they were, that can be a little more difficult to prove. That might need expert testimony. At that point, you might need to get an attorney involved. But again, if the thing just doesn't work at all, the consumer themselves can provide testimony as to the value, and the value being really absolutely absolutely nothing. And then the again, sort of tied into the remedy are the requirements for the various type of breach. So, for example, with breach of implied warranty, where you're just looking at the condition of the product when it's sold. So, for example, you unbox it and it's broken. You don't have to give them another chance to repair it. There, it's unmerchantable as sold. You're entitled to cancel the contract and seek relief. In contrast, for things such as breach of express warranty, you may need to give the manufacturer as it says here, a reasonable opportunity to repair the product to some extent. That is why warranties exist. Something's not necessarily lemon just because it has to go in for repair once. And so once you have given a reasonable number of opportunities, which can be set as a matter of law or by the discretion of the jury, or frankly, it's a judgment call by whatever attorney gets involved, then you're able to seek relief. One question that might come up is whether a manufacturer can use, say, replace it with refurbished or used goods. Like I said, in California, certainly not. In other states, potentially, but frankly, depending on the state that you're in, if say you're a state that does not have a strong lemon law, or otherwise, where you're otherwise just relying on Article 2, refurbished good might be better than diminution of value, or might be better to prove. One place, generally various states, AG offices will have websites that provides good summaries of various lemon law rights under the different states. Given, frankly, how sort of broken the internet is these days, that's probably your safest bet for where to figure out what your rights are under the various states' lemon law. So we know now the lemon law generally refers to breach of warranty. It in theory covers everything, and your rights range from diminution value to repurchase. You can also recover often consequential or incidental damages. For example, at an extreme level, a smartphone battery catches on fire and burns your house down. Your damages are not limited to the damage to the smartphone. It's you have consequential damages of the entire property value of what was burned down, and that's the ability to obtain consequential damage is in the commercial code. That's something that should apply to all 50 states, or certainly 49 states minus Louisiana. You also potentially could recover sort of business loss damages if this is, the device is used for business, it goes down, you've lost sales. Those could be recovered as consequential damages under the commercial code. You may have issues, recovering under Magnuson Moss or under Consumer Warranty Act, and so there's a bit of a trade-off whether you want to seek those. And it also those type of damages can be more difficult to prove. Generally, you cannot recover emotional distress damages for a simple breach of warranty. In California, there's a case called Conn versus Mercedes-Benz that in various sort of layman terms, basically says you have to prove that they were out to get you and intentionally did this to you, and that no court has ever actually seen that. So the door is slightly open, but I don't think any of us are ever going to see a case where you can get emotional stress damages purely for well, a lemon law breach of warranty. Certainly not without physical injury. So now that we know this, if we want to turn to sort of how do you enforce your rights? And this will be kind of the meat of the presentation. The simplest thing, and this is probably obvious to everyone, but it can't be stressed enough, is if you don't ask for relief, no one's going to give it to you. And oftentimes people will resort to attorneys or community centers instead of just going, calling the manufacturer, asking for a refund, going to the store, asking for a refund. Even I've seen people have a lot of success on social media. DM them on Twitter, I guess X, Instagram, and ask for relief. It's like I said, no one's gonna give you anything if you don't ask for it. And asking, in many cases, sort of the worst they could do is say yes. In California, under the Song-Beverly Act, if the jury finds the manufacturer willfully violated their warranty obligations, the jury had discretion to award a civil penalty of up to 2 times actual damages. Willful generally means that they knew what their obligation was and intentionally declined to fulfill it. And one of the easiest ways to show willfulness is to have the consumer make a request for relief and get denied. There are also, certainly California and other states have enhanced remedies for senior citizens. California has Civil Code Section 3345, which gives a jury discretion to further treble, so award further up to 3 times additional damages than they otherwise would be able to upon a showing of 1 of 3 factors. And one of the factors is just that the bad actor knew or should have known that their conduct was directed towards a senior citizen. And again, having the person call and ask and say, I'm a senior citizen, I deserve to be treated better than this. This is costing me a lot of stress. Please buy back this piece of junk. It's gonna be tough for them to, if the person told them they're senior citizens, it'd be very tough for them to deny that later on. And also, again, no one but lawyers enjoys being in litigation. I think most lawyers don't even enjoy being in litigation. And if someone can resolve it on their own quickly, that often will be the best for them. Another option, or another, I guess, potential option would be resorting to what's called a non-binding arbitration. And this is distinct from binding arbitration, which we'll discuss in a second. But under the Maximus Warranty Act, the manufacturers have the option of setting up what are called informal dispute settlement procedures or informal dispute settlement mechanisms as a prerequisite to a lawsuit being filed. So the Maximus, and you can look at I think the FTC and the CFPB websites for more information on this, have very specific requirements for what these IDSPs must consist of. They must be conspicuously disclosed to the consumer on the front page of the warranty. They must have certain fairness mechanisms, and they must issue decisions within 40 days of the hearing. And most importantly is that they must be non-binding on the consumer. So it creates a quick situation where the consumer can present the dispute on their own without the assistance of an attorney. Again, that's another requirement, that it has to be accessible to consumers. And the best case is they get an award in their favor and everything's done 40 days after that. Worst case is that then they have to move forward. Depending on the state, the only sort of downside is the decision in the non-binding arbitration may be admissible at trial. And that's the one thing to caution about. That it may make the case a little harder, but at least personally, I would never let a bad non-binding arbitration decision stand in the way of an otherwise good case. The next issue is a little trickier, and that's the idea of going to binding arbitration. The first issue, and I'll just touch on it briefly, is whether or not warranty disputes are subject to binding arbitration. Congress in the 1920s passed the Federal Arbitration Act, which was really originally designed at business-to-business disputes. Prior to the passage of FAA, businesses would agree to go binding arbitration. Whoever side lost, was not happy with the result, would not follow it, and courts were reluctant to give effect to private arbitration decisions. So the FAA really went overboard to give effect and enforceability to arbitration. Beginning in the 1960s, the FAA arbitrations sort of morphed, and the U.S. Supreme Court began to apply it more and more to consumer disputes, going more through the 80s, 90s, and today, where essentially any contract that you sign, any terms and conditions, will have a binding arbitration provision in it. It would almost be malpractice to not include it. And certainly, most warranties will have binding arbitration provisions in them. I'm very confident Samsung's warranty does. Apple, to some extent, may be an exception, but it has been a few years since I've looked at Apple's warranty, so that may have changed. However, the Federal Trade Commission, in interpreting the Maxim-Moss Warranty Act, has determined that because Maxim-Moss creates these non-binding arbitration provision, that therefore warranty disputes cannot be subject to binding arbitration. However, the majority of appellate decisions, as prevalent, have disagreed and have found that the deference that will be normally given to administrative agencies that should not extend that far, and have found that warranty disputes should be subject to binding arbitration. One exception has been the Ninth Circuit Court of Appeals, however, which is the sort of the West Coast largest federal appellate court. However, that decision was subsequently withdrawn. So as a practical matter, I more likely than not, I think a court would, if the arbitration provision is otherwise valid and formed, a court, I would say more likely than not, would send the case to arbitration. The downsides of arbitration is that you are giving up your right to the trial by a jury of your peers. There are limited appellate rights, so the decision is somewhat binding, and there's also limited discovery. The sort of upshot of arbitration is, well, first, the limited appellate right is a double-edged sword. Whatever's binding on the manufacturer or the warrantor is also binding on you. However, our arbitration is expensive, and as part of the push to develop good case law to make arbitration agreements enforceable, the warrantor, these arbitration provisions will generally provide that the warrantor is the one who has to pay for all the arbitration, and you're paying a retired judge or a practicing attorney, hourly to see this dispute, and very quickly, I mean, truly probably within a few hours, the cost of the arbitration will outweigh the value of the dispute. So by going to arbitration and demanding arbitration, in addition to the fact that it is a faster, or potentially faster way to resolve a dispute, there is less formality. It's something in theory a consumer can do on their own. It would also could incentivize the warrantor to just resolve the matter, since it will, as a just practical matter, it will cost them more to proceed with arbitration, even if they win at the end of the day. There's a growing trend with arises with mass arbitrations. Part of the reason why manufacturers, mortars, and everyone puts in these arbitration provisions is to kill class actions, where a class action waiver outside arbitration provision may not be enforceable. Per the U.S. Supreme Court, if you place it inside the arbitration provision, it is enforceable. So creative attorneys have, instead of bringing one class action, will sign up hundreds, if not thousands, of clients and bring the same number of arbitrations, where the manufacturer or the warrantor or otherwise defendant has agreed to pay $5,000 administrative fees per claim, and that's still sort of playing out in the court systems. So arbitration can be an option, and especially given how impacted courts are these days, potentially a viable one that a consumer could go through on their own. Then the last option is, of course, file a lawsuit. Given the amount that we're talking about for disputes, for many states, it's probably most, if not all states, small claims court is an option. I have to imagine most smartphones and devices are within the small claims court limits. In small claims, there are no attorneys involved. They're used to in pro se parties. If it's a very clear breach, yeah, I think it's something that most consumers can handle, especially with guidance. But then on the other hand, most, or if not most, mini lemon laws have what are called attorney fee shifting provisions. So fee shifting provisions are determinations made by Congress or the relevant state legislature that lemon law rights or civil rights or employment rights are important things for normal people to be able to enforce, and that they should be able to obtain and retain competent counsel without any out-of-pocket cost. And so a fee shifting provision would provide that attorney's fees become part of the recovery in addition to the damages available. Often, even with some of the most expensive cars, by the time a case gets to trial, or some of the most expensive products, the attorney's fees greatly outweigh the recovery at trial, or even the potential recovery at trial. And so it simply doesn't make sense, and would not be viable, except for truly the most expensive purchases, for the cases we take on contingency. So without fee shifting provisions, the lemon laws are essentially toothless, which is why they're included. And so the point of all that is, even for small dollar products, smartphones, devices, appliances, it may be possible to find counsel and be able to the consumers have someone represent them in the case. I mean, I've personally handled a wide variety of consumer goods, faucets, wheelchairs, boats, trailers, RVs, and well, with most attorneys, the bulk of my practice, my lemon law practice is cars. But a small dollar value with the fee shifting provisions is not a deterrent. So in sum, the lemon law can provide important relief and remedies, and it's something that should be available to most consumers. And if there are any questions, I'm more than happy to entertain them.
Thank you so much, Elliot. Thanks for that information. A lot of practical tips there. I'm sure we're going to have some questions. We'll get to those after we hear our presentation from Nathan Proctor. Nathan, are you there? I'll advance your slides.
I am here.
Great.
I'm happy to be. Hello, everybody. All right, so it's been a few minutes since you were introduced to me, so I'll quickly reintroduce myself. My name is Nathan Proctor. I am the Senior Right to Repair Campaign Director for the PIRG network, and I believe you should be able to fix your stuff. And if you advance to the next slide, I can go over the agenda a little bit. that I'm going to talk about, the problem of unfixable products, the policy that we've been working on, what right to repair is and what it attempts to accomplish, and kind of an update about where we've made progress and kind of what the latest is on right to repair. But I'm going to start with the story of a single day where two products broke, and I think illustrates some of the things that we're doing. So if you want to go to the next slide, you will see my friend Paul's KLH radio. I'll give Nelson a second to find the next key. There you go. KLH radio, which was sitting on his hall table. It's a beautiful, warm-sounding, radio from the 1960s. His dog Bruno, that rascal Bruno, grabbed the power cable and yanked it right off the table and pulled the plug right out of the back of the radio. But despite the fact that this product is more than 50 years old, if you go to the next slide, you can see that Paul was able to locate a detailed diagram of the main amplifier electronics so that he could determine what was what. And he even had a flow chart diagram. And if you go to the next slide, you can see for the circuitry. And he was able to figure out that his problem was that it's labeled a F1 there, but he had blown a fuse, and he was able to replace that fuse and fully restore his ancient radio. And Bruno was not too severely punished for the infraction. But on that same day, his daughter broke her Fitbit 4, which there's a picture of next, which is a smartwatch and a fitness tracker. And the most detailed diagram in the Fitbit manual is what you see on the next slide. This very illustrative instruction on how to do a clasp. There's nothing about any of the other components or electronics, and you can see what broke on the next slide, which was a tiny plastic clip that connected the watch to the band. There's two little nubbins that snapped off, and because the watch was still under warranty, Fitbit did replace the product, but it kind of speaks to this underlying problem, which is we used to build and deploy things in such a way that when they broke, we fixed them. And we have limited that. We've scaled that back. So now so much of the things that we get, the only remedy is to replace or to take it back to the manufacturer, who's the only one with access to the parts, tools, and information. Right? You can't find the Fitbit circuitry diagrams with a 5-minute Google search online like you could the KLH radio. They just aren't available. And the results are extreme. And so this is two products, but let's talk about smart cameras for a second to kind of illustrate why this is getting to be such a problem, which is the next slide. So modern DSLR cameras are obviously an extraordinarily popular item across the country. People have nice, expensive cameras to, take family photos, and photography is obviously a very popular hobby. And you can imagine, if you look at the components on your screen, that if you didn't have the manual or access to those individual electronic components, how difficult it would be for anyone to do the repairs to that camera. I mean, that stuff is really packed in there, and basically every piece is specialized for that device. But if you go to the next slide, you see the problem that we're facing, which is that, this article is 5 years old now, but Nikon ended. It used to have an authorized repair program where there'd be local shops that could join a network and get access to the parts, tools, and information, and then they just ended that program. So now that there's only one way to get these products fixed in the U.S., or there, up until I think, we'll talk a little bit more about the right to repair gains, but there were 2 locations and they were all mail-in locations, and they pretty much were only fixing things under the very limited terms of their warranty. And if we go to the next slide, we get a sense of, the system that we have now is one where, consumers are burning a lot more money buying new things. Repair businesses are struggling to operate, and we're creating a massive amount of waste. And in fact, electronic waste is the fastest growing part of our waste stream. The UN calls it a crisis. Electronic waste is growing 5 times faster than the capacity to recycle electronics. And if we don't do something about this, we're going to be just drowning in throwaway gadgets. And so we set out to try to make a difference on this problem, working with our allies in the consumer movement, environmental movement, and then also there's a coalition called repair.org, which you can check out, to fight for model right to repair legislation, which I'm going to go over on this next slide. So our solution to being able to allow consumers to have a choice of repair, to have more things get fixed and less things have to be replaced, is to require original equipment manufacturers, people like, General Electric and Kenmore, Whirlpool, Apple, Google, John Deere, to provide access to whatever materials are necessary to fix equipment, the things that they make available within their own authorized service networks. So that, and we split this into 3 categories in our model legislation, namely that parts, tools, and documentation. So parts are, whatever service parts that the manufacturer has available for their own repair services. Tools are the physical, or increasingly and crucially the software tools, which are very important to diagnose, calibrate, or reset equipment post repair. And then the documentation, the things like those diagrams we showed you earlier, how the thing is put together, how to take it apart, and what goes where, and allows people who know, especially around circuitry, how to diagnose and fix very, very small components, which is usually the most affordable kind of repair that a consumer can access. So if you go to the next slide, we kind of built this approach based on our friends in the auto care association at the aftermarket for car repair. I mean, people know that you can, if you have a car, you can take it to the independent mechanic, or you can take it to the dealer, or you might be able to fix it yourself. Now, this has started to get harder and harder as we've moved into a more computerized, software-dependent car environment. And so the people who fix cars, the independent mechanics, in order to protect their ability to keep repairing our cars outside of the dealerships, they put together a right to repair package, and it was passed in Massachusetts. It actually went to the ballot and passed 86% to 14%, which, interestingly enough, is a greater percentage of Massachusetts residents than actually own a car. So right to repair for automobiles is more important than automobiles. And the parties after that reached a national agreement which codifies rules around providing information to mechanics necessary to fix equipment, as well as standardizing certain computer diagnostic tools, which, if you're a car person, you know as the OBD2 port. That's the onboard diagnostic port, which is where you get service information. If your check engine light goes on, that's what you plug into to see what the heck is going on. And so that really helped inform our approach to right to repair. partially that we wanted to do it in the States, and then also that they had kind of figured out the structure for how to make a legislation like that work. So where have we made any progress, you ask? Well, I'm glad you did. If you go to the next slide, you can see a map. This is from repair.org of all the states where we have active legislation so far. And that's in the dark red color so far this year in 2024. I says 45 states there, but it's actually 48. I didn't update that number. We've had 48 states that have introduced right to repair laws, and each bill, some of the bills are very broad and cover every piece of equipment, and some of them are more targeted to very specific pieces of equipment, like just farm equipment, or there's actually a bill that has made some progress in Missouri that's just motorcycles. And we've passed legislation now, besides the initial car legislation, in 5 states: California, Oregon, Colorado, Minnesota, and New York. And this has been a broadly bipartisan work that we're really proud of. So I wanted to start and just talk a little bit about the bills that have passed and what they do. So the first one is, and you can go to the next slide, is this was actually the first one that we passed, which created rules for the right to repair for powered wheelchairs. And people who are dependent on a powered wheelchair for mobility were kind of, at our first hearing in Colorado, they came with a large number of testifiers to talk about the just nightmare horror stories that they had of having their chairs break and having no one be willing to fix them, and the distance that they had to travel to get these chairs assessed, and then multiple visits, and the downtime was, I think it's 6 to 8 weeks on average. And I remember one of the people affected, said in testimony that, like, if car users were waiting 6 to 8 weeks on average to get their car back from the car repair technician, that there would be riots in the streets. It was a very difficult situation for people, and so we decided, after hearing that testimony, that we would partner with CCDC, which is the Colorado Cross Disability Coalition, which advocates for the needs of people with disabilities in the state, to pass the first wheelchair right to repair law, which requires the manufacturers of the wheelchairs to make available the parts, tools, and information to the owners and independent technicians to service these chairs. And a lot of times it really is these software tools, which, even if they could get something fixed, they struggle to be able to address the software needs of the chair. And then the next bill that we passed was in New York. Our first ever right to repair law for electronics. And pretty quickly after that, we went back to Colorado and passed, and we have a picture of Jared Polis signing this bill on the next slide, the first ever right to repair law for farm equipment. And you can see we actually drove a giant tractor to the Capitol steps in Denver, Colorado. And you can see we're there with Jared Polis, as well as the Rocky Mountain Farmers Union, which advocated for this policy. I mean, you can probably guess that if you are dependent on large pieces of farm equipment to harvest or plant or fertilize your fields, that when that equipment is out of service, you're in a very vulnerable situation. Like, downtime is dying time, as they say. And so there was a ton of advocacy that went into making sure that farmers had the same parts and tools, especially the same software tools that the dealers had, so that they didn't need to have these expensive dealership calls when their equipment was out of service, that if there was something that they could fix themselves, that they would have the ability to do that. And then interesting. So the next bill we passed is California, which is interesting that Elliot was talking about the Song-Beverly Act, because we actually amended the Song-Beverly Act in California's approach. It was actually like building upon the warranty law there. And it requires manufacturers who have a product which is covered by Song-Beverly to make available parts, tools, and information for their products necessary to fix them to owners and independent technicians. That was probably one of the better bills we had passed so far. It came through very strongly. And then we took it up even further when in Oregon, which you can go to the next slide, we passed a law that even doubled down and went really specifically about some of the software restrictions companies put on devices that makes them difficult to fix. And then, just 2 weeks ago, we passed the right to repair bill in Colorado, which kind of makes Colorado, kind of have the broadest and most secure right to repair rights of any state. So if you go to the next slide, you can kind of get a chart of what all this adds up to, what was covered in these different bills, the effective date, and and how far back the legislation reaches in terms of which products are covered. I think ideally we would have a bill that just says, no matter how old the product is, if there are parts or tools or documentation that the manufacturer has access to, they should make that available on fair and reasonable terms to anybody who wants to fix those products. But manufacturers really didn't like that idea. And so far, we've kind of set up July 1st, 2021 as I don't know, I guess that's become the date that is most likely to be put in one of these bills, and for as far as any equipment that was made or first sold after that date will be included. But some of the older equipment won't be. There should be a little asterisk there on Oregon, because in Oregon, actually, it reaches back towards July 1st, 2021 for cell phones, and then it reaches back to 2016 for every other kind of home appliance. So, your dishwasher and your washing machine, hopefully we cover a lot more of those products. Unfortunately, that bill doesn't go into effect for another 1.5 years here, but in just 6 weeks, both the Minnesota and California laws will be in effect. And so these requirements, which are really now only in New York, will be extended to Minnesota and California, and we should see a pretty big difference in access to parts, tools, and information. Especially looking forward to, we made reference to cameras. This is something that there really is almost no support for that kind of repair, and hopefully on July 1st we'll see that. So next, I kind of just want to give a little bit of a sense of what right to repair has done at the federal level. I mean, as you can see, most of the work that I've gone over has to do with state right to repair laws. But we've been working extensively at the federal level, and in fact, I was just in DC yesterday working on this stuff. So I would say our work started in 2019 when, if you go to the next slide, we did an investigation as to how manufacturers were complying with certain criteria within Magnuson-Moss. And so Elliot gave you a lot of information about Magnuson-Moss Warranty Act. But there's two pieces I wanted to highlight. The first is manufacturers must make the text of that warranty. If they have an express warranty, a written warranty, they have to make that text available to you before you purchase the product. That happens sometimes and doesn't happen other times. But the bigger problem that we found was Magnuson-Moss also says that you cannot condition the warranty on exclusive use of the manufacturer's services or any kind of name brand parts or tools or things that you would use. Like you can't say, I void your warranty for your vacuum cleaner because you did not use, my brand vacuum cleaner bags. Not that vacuum cleaners have bags anymore, but I'm sure there's some of you who remember those bag days. So we found that 45 of the 50 companies that we contacted, major appliance manufacturers, would tell the customer that the warranty was void if they had sought self-repair or independent repair. And that is pretty much forbidden under the rules of Magnuson-Moss. So we really put a lot of pressure on the Federal Trade Commission to do something about this, and that kicked off their investigation. So if you go to the next slide, you can see this is me testifying at the Nixing the Fix workshop held by the FTC in July of 2019, where we were, we discussed what was happening. We gathered public comments, experts testified, and the FTC, kind of disappeared. They didn't hear back from them for a while, but they were working diligently on a report called Nixing the Fix, and there's a little summary of that next. That they issued this report to Congress in 2021. Congress actually had to pass an appropriations measure requiring the FTC to do this, but they did that. They found after their investigation that manufacturers could not justify their behavior on refusing to let people fix products and offering no support, no parts, tools, or information in support. And they had scant evidence or no evidence to support their claims that, making these things available would undermine consumer safety or privacy or cybersecurity. It was basically, it was unanimous from all four commissioners. This was still, the FTC was still, bipartisan with 2 Republican appointees and 2 Democratic appointees at this time. This is kind of one of the last big unanimous things that FTC did with that group. And then shortly after that, 2 months after that, on July 9th, you go to the next slide, President Biden signed an executive order promoting competition, which made right to repair an official policy of the executive branch. You can see him handing the pen from this executive order to the chair of the Federal Trade Commission, Elliot Conn. And since then, and there's a little bit more on the next slide, a couple weeks later, the Federal Trade Commission issued a new policy statement to pledge to devote more resources to combat any unlawful repair restrictions, and that they were taking our warranty research pretty seriously, and they're going to start taking action against violators of warranty law. And one of the results of that is, if you go to the next slide, the Federal Trade Commission actually reached a settlement with Harley-Davidson and Westinghouse. They also had a similar penalty against Weber Grills for basically trying to weasel out of the warranty obligations. In the case of Harley-Davidson, it was like, well, you made adjustments to but you tuned the bike, or you have an aftermarket tow hitch, or they had a set of things that voids your warranty. And they said you're not allowed to do that. You have to inform your customers of their actual warranty rights, and you have to compete fairly with independent repair technicians. And then, most recently, I've been talking a ton about warranties because there's been a big dust up from the gaming world. So there's a screenshot on the next slide. I totally recommend people to check out this very informative video by Gamers Nexus on Asus, which is a computer hardware manufacturer. He had product, an Asus product that he shipped in for a warranty repair, and they denied his repair because, or they initially denied the warranty claim because they said that there was damage to the product, like customer-induced damage to the product. And if you go to the next slide, you can see the damage that they referred to, a tiny cosmetic scratch in the housing, and they said that they would have to, replace the entire, assembly, including the screen of the device, which was working fine. Was totally unrelated to the warranty problem that they sent the product in for, which was a joystick malfunction. And you can see on the next slide, some of the justification, that they basically said that if you don't agree with us, we'll just ship you back the device unfixed and potentially disassembled. So this is not okay. And one of the things that my warranty investigations have found is that companies will often tell you things about warranties which are just not factually true. The company is required to address defects in workmanship or in design for their products, regardless of if you made some slight modification to it, regardless if you didn't exclusively use their vacuum bags or oil filters or whatever they say you have to do. And the reason why that exists in consumer law is this idea of tying. And tying is when you use one sale to kind of coerce or push or force the customer to purchase something else from you, whether it is a good or an additional service. So I bought this car and I didn't realize that I now need to go to the dealership for all my oil changes. That's a tying arrangement. It is a kind of sneaky way of getting more money from somebody. Now, one of the ways that you can execute on a tying arrangement is to threaten their warranty. Listen, if you do this, I will void your warranty. I will not honor. You will be left out in the wind if you don't do what I say. And one of the problems with this is it's just very easy for manufacturers to say this or for salespeople to say this, and it works a lot of times. Consumers are worried about this, but the truth is, whether or not you do those things, whether or not you pay for their super overpriced oil changes versus going to an aftermarket, they have to honor their warranty claims. That is their obligation, and it is not legal for them to use that to force you to pay for anything else from them. And one of the problems, obviously, with enforcing this particular set of conduct is if you don't actually pay them, right? If you say, no, you're wrong, that's not what warranty law says, you're going to fix the thing that you got wrong and send it back to me or hand it back to me. If you at that point, there's no actual damages, because you were able to resolve the situation. So it's the only remedy for us in this case. First of all, we want to educate consumers to stick up for themselves, to make sure that they understand and know that they have a right to get these problems with their products addressed if it's under warranty, that other things that they do with the products that are unrelated to that do not implicate their warranty. It's important, like if you advocate for yourself, often they will relent, which is in the case of this video. Asus eventually relented and just did the free in-warranty repair and ignored these other non-issues that they were trying to rattle the customer into paying for. But what do we do? Like, it's just too easy to do that, and this happens too much. I mean, 45 out of 50 companies that we surveyed were making these kinds of statements to customers. So one of the things that we've been really working hard on, and this is kind of my final call to action, and you can go to this next page, is the FTC has been working since July of 2021 to advance better compliance with warranties, better consumer protection on warranty work, as well as just supporting a more robust repair ecosystem as something that's good for consumers, good for the planet, good for competition. And so they have requested, and this is from last month, they've requested stories about warranties and repair. And so you can, I'll make sure that Nelson gets a link to this page, but if you do have, if you're working with somebody and they have a warranty issue and it's not easily resolved, or even if it is, to report that information at reportfraud.ftc.gov, to give that information to these regulators who can then make sure that these companies know that somebody's paying attention to how they deal with their warranties, that they're obligated to resolve issues for their customers if indeed there are flaws in their products design or workmanship in their creation, and that people have the right to fix things otherwise without imperiling their warranty. So with that, I will wrap up my presentation and we can get into questions.
Thank you so much, Nathan. Wonderful presentation. Thank you again, Elliot. And I am sure we have questions for you. Monica, are you on? Can you let us know if we have questions for the speakers?
I'm on, and we have a lot of good questions. So I can get right in there with the first one, which is for Nathan. Was Biden's executive order on right to repair just a statement position, or does it help us lawyers fight the issue?
Can you repeat that? I'm not sure I totally caught the meaning of that.
Okay, the person asked, was Biden's executive order on right to repair just a statement position, or does it help us lawyers fight the issue? Does it have?
Yeah, he created an executive policy which prioritized using the agencies to improve competition in the United States. And there's a lot of different elements to this, right to repair being one. The other thing that was part of that executive order was they created this Office of Competition within the White House. Now the White House is coordinating with different agencies and helping them understand. So like a good example of this might be, we've worked extensively in the medical device space around issues where medical device manufacturers will routinely refuse to let competitors fix their equipment, either by denying service, passwords, or parts, tools, trainings, as a way to get hospitals to pay for their much more expensive manufacturer authorized services. Now, that's an issue which is an FDA issue, right? And the Food and Drug Administration is one of the executive branches. So now that there's a point of contact, if you want to raise a problem, and maybe the FDA is like, well, we're not really competition experts. All we understand is patient safety. So now you have some cross-agency collaboration to kind of get to some sort of a more informed decision on a topic like that. So I've found it to be quite useful, and I think that probably in terms of the FTC, the more important and more useful thing for lawyers to examine would be the 2021 statement that the FTC put out on their, how they're going to, pursue enforcement. I think that would give more, information on, for those folks. for an advocate like me, I now have a point of contact when I see a competition issue, which maybe touches more than one executive branch.
Great, thank you. And now a question for both of you. What do you think about purchasing an extended warranty or insurance, also service contract to cover phones and computers? Do you have any advice on that? They're always pushed when you buy your device. Is that what we should be doing?
So I think statistically, the answer is no. I mean, they obviously wouldn't be selling them if they weren't making a profit. There's tremendous markup. There are interesting use the word extended warranty. There are very few true extended warranties out there. They're generally disguised service contracts.
Mm-hmm.
There are a lot of differences between the two, but the most important is the remedies for breach. So generally, the remedy for breach of warranty is either they have to buy the product back or at least pay damages. The remedy for breach of a service contract is they have to just service the product. Certainly, if you're buying something new, if there are issues with it, they should arise before the original warranty period's up. So that there's no reason to buy it. On the other hand, it does give people peace of mind, and if people feel more comfortable buying it, it might make them feel a little better. But personally, I will never buy an extended warranty.
Yeah, I mean, I think Elliot and I are on the same page on this. You know, I don't buy them. I think the real way to protect consumers is to ensure that there's a robust ecosystem with many competitors for repair of post-warranty products, that is generally far cheaper than the cost of the extended warranty. The other part of the extended warranties that I really am concerned about is, you know, I believe that the ability to sell extended warranties to customers, which again are an incredibly high margin product for the manufacturers, is often, you know, conditioned or influenced by the lack of repair options. So if the manufacturer is the only one who can fix something, and they want you to pay, you know, $99 a year in perpetuity to get access to repair, and if you don't have that access, you can't get it fixed at all. That's more of a protection racket than a protection plan. You know, yeah, I would be ashamed if something happened to that phone, you know, but, you know, I don't like that at all. I highly object to the way that those two things are related. And so I think people should try to support. The real peace of mind is when you have a technician that you know and trust in your neighborhood who can fix anything and charges you a decent rate and doesn't give you the runaround. And that's the kind of protection that I want for more communities in this country.
Right. That's really helpful. I know that's a really common question for people, and often it hits them right as they're at the checkout counter and have to make a quick decision. So, Nathan, somebody asked, you know, for those cases where, you know, these companies say you have to buy my vacuum bags or your, you know, warranty is void, whatever, are there penalties for companies that mislead consumers about limitations to warranty and right to repair?
So and Elliot would probably also be able to answer this question really well. The FTC is severely limited in their financial, what is it, engorgement or whatever it's called, their ability to get financial penalties from companies on this stuff. It's quite difficult for them to do this. That power has been limited by the courts. However, you can bring cases like you can work with the state AG or private case if damages have been suffered. Now, damages can't be suffered just because they told you something that wasn't true. That's a deceptive act, but there's no, like, if there's no financial damage to you, even if you if you end up paying for something that truly you didn't need because you were coerced into it through some kind of deceptive business practice, then that's quite serious, and that is the cause, that can be cause for financial damages. But that would be the conditions that I see.
I would say if they are denied, if you have a product, you buy the vacuum bag, something unrelated breaks, and they deny warranty coverage because of something that's illegal, you present with a reasonable opportunity to repair. I think certainly under California law, but under mini state laws per se. And if they refuse to repair it, they've breached warranty. So you could sue for damages under the lemon law. And if they actually, again, are enforcing or advertising these unlawful disclaimers, you could presumably bring claims under the relevant states, UDAP statutes, so unfair deceptive acts and practices. So I mean, as a sort of private attorney general, you could seek relief to enjoin these bad acts.
I would recommend, if you're working with somebody who's experiencing this, to just be insistent and clear in the communications. No, that's not what federal warranty law says. I expect this product to be fixed. And my experience is, if you're a customer and you stick to it, they eventually do it, because they totally understand what Elliot is saying. If they actually fully deny the claim, and they're opening themselves up to something. So my sense is that generally, if you're persistent and you just keep sticking with it, no, you got to do this, you got to do this, eventually they relent.
Okay. This one I think is for Elliot. Do you have any tips for how a consumer should respond to a rejected claim that they believe is actually a valid claim? Do you see cases, for example, where somebody, says their phone is broken and the manufacturer says, well, this is because you got it wet or you dropped it or you did something, but you actually didn't. It actually should be a valid claim, but you're getting pushed back.
So I know years ago, and I was not involved with this, there was class action litigation against Apple that the moisture sensors on the iPhones were way too sensitive, and basically if you had your phone in the bathroom while you took a shower, maybe in a humid environment, it would show up as water damage. I frankly I don't know the outcome of that, but that is definitely that occurs in litigation. Unauthorized use or unreasonable use, such as damage to the vehicle, is an affirmative defense to a lemon law case. When there is an accident or modification to the vehicle, attorneys generally will be more reluctant to take the case. I've done well on those cases so far. I do somewhat understand the risk. Perhaps I don't appreciate it as much as I should have. But that's you have the idea there is you bring the case, you prove it, and then you make sure they can't prove their affirmative defense. What's nice about lemon law cases, though, is generally you just have to prove there's a defect, not the cause of the defect. And so the burden is on them to prove that the defect, that whatever the damage was, is more likely than not related to what the defect is, and that's fairly difficult for them to prove. So I do see it. It's in terms of tips, sort of pre-litigation. There's not much you can do other than be very, very clear and deny it. But and then if not, you have to get involved in litigation.
Okay.
Yeah, and my only other tip would be to just if you're working in a case, in a situation like this where you're worried that they're going to deny the claim, document everything as much as you can. Yeah, if you have documentation to support, like if you take pictures of the product before you send it in the mail to them, et cetera, that's usually a smart thing to do.
Okay. I think another common question, because I'm seeing it come up in our thread here, is when you first have a claim or believe you have a claim, Do you go to the retailer or do you go to the manufacturer? And is there an issue with each of them says go to the other person? If the retailer is not the manufacturer, like if it's not an Apple store, it's Best Buy, who do you go to? Where do you start? And who's telling the truth about it's the other guy?
It somewhat depends on the issue. So and who's at fault or who's liable. I think ultimately the buck does stop with the warrantor. So as part of the sale, the manufacturer makes the product, issues an express warranty, saying we promise the thing will work for the next 2 years. The retailer, in selling a product with a written warranty, they're also providing an implied warranty merchantability that the thing is what it is and it works at the time of sale. The retailer would have a right of indemnity against the manufacturer. However, they are also as the implied warrantor, they have liability as well. So you buy a product, it just doesn't work. I think the easiest thing is just go to the retailer. If you bought it new, it certainly, or potentially, depending on how bad it's even used, it doesn't matter if issues arise during the warranty period. You're probably better off going to the warrantor or the manufacturer.
Okay, great. Nelson, do we have time for one more?
Yeah, I think you can squeeze in a couple more even.
Okay.
Yeah, I'm happy to keep answering questions.
Okay. So here's one about secret warranties are not uncommon when it comes to car issues. And of course, that's the practice where manufacturers will repair a particular problem for free, even though it's outside the warranty period, rather than issue a a recall for a known defect. But often it's only if the consumer pushes the issue. Now, are those secret warranties and out of warranty covered repairs happening in the world of phones and computers as well? And if so, how does a consumer know whether their out of warranty issue is something they can push to have the manufacturer repair?
Yeah, so that does happen. Very similar things, which is like, the company realizes that there's a part of a computer or other device that is prone to failure, and if they get the device in their hands, will quietly replace that, or remedy that situation. There's no requirement that any of that information be disclosed. It's kind of a black box. So yeah, I mean, unlike with autos where you can kind of get this information. I know that PIRG has gone to used car lots from like CarMax and found all the known recalls and see if those addressed are in the cars there, and they're not typically. But that is no similar such database of defects is to be found unless a recall is triggered by the CPSC.
Okay. Let's see. I'm just going through these. Nathan, for those who want to support the right to repair effort, what should they do? How can they get involved?
What a great question. Well, I mean, so if you just look at our campaign page, which is PIRG.org. I think it's PIRG.org/repair. I'm gonna just check that if I still have that shortcut working. Yeah, if you go, no, PIRG.org/campaign. Is it campaign or campaign? Sorry, give me a second. Yeah, PIRG.org/campaign/right to repair. You can see this is our main campaign page where we list all the state bills that we're working on. And you should get, if you're in a state, you should get prompted to look at your own state organization. And probably the easiest way to get information on right to repair would be to sign one of the petitions at the bottom of the page, and then you could be added to the mailing list. and we'd love to keep you up to date on all the things going on, including in your neck of the woods.
Great, thank you. I think we can probably close with this one because today's a train the trainer. So people on here, many people are doing, community education. If you could just give a key message or a couple messages that you think are most important for them to take away to deliver to their constituents, their clients, to improve their experience dealing with warranty issues and help them protect their investment in what are now very expensive devices.
I'd say push back. We're dealing with these for-profit companies that everything's sort of a numbers game with them. If they're denying warranty claims that are valid, it's because they've made the calculation that not that many people will actually go all the way. There's a reason there are robust warranty protections in place. There's a reason there's a fee shifting provision. And people should know they have warranty rights and try to enforce them.
Great.
Yeah, and I think that's perfect.
All right. Well, thank you very much. Nelson, I think it's back to you.
Thank you so much, Nathan and Elliot. Fantastic presentations, and thank you for powering through so many questions. We have a couple of slides just to close, and I do please, if you're on standby for a quick poll as soon as we're done, we'd like to learn what you thought of this and also hear what you might be able to do with it, hear about what you might be able to do with it. Reminder that we are a nonprofit, and if you'd like to make a contribution to consumer action, you can do so online or by mail, as we have on the slide, and you'll get these slides. So you'll have the information. You can also support us by, without spending a cent, by subscribing to our YouTube channel. This is another way to support us, as well as following us on our social media pages. Thank you again to the speakers and audience. Thank you for being on and going over with us just a couple of minutes here to get to these questions. Watch your inbox for upcoming events, and we look forward to seeing you next time. Goodbye for now. Thank you, Elliot and Nathan.